All right, how you doing? Jonathan Johnson from Lake Charles, Louisiana, right here at the Johnson firm. I'm with Erin Abrams today, again, a partner at the Johnson firm, and both of us practice in family law, and we're going to talk to you today about a subject that is one of our favorite things to do, adoption. There are different types of adoption. The one we're going to talk about today is intrafamily adoption, normally referred to as step-parent adoption. We're going to kind of go through some of the factors that you need to be aware of, when you can do it with consent, without consent. So anyone that's ever thought about, they've gotten remarried, they had kids from a previous relationship, and they've thought, what does it require for an adoption? Let's take them through it.
Yeah, absolutely. And so again, when we're talking intrafamily, you're correct. Typically, we're talking about a step-parent adoption, but sometimes that can apply also to other blood relatives, depending on the closeness. It's called the degree of collateral, okay? So this could apply to more than just step-parent situations. Typically, for intrafamily adoptions, there's kind of I don't want to say a two-pronged test, but there's two phases of it, okay? First, someone has to show to the court that either the biological parents have consented to the adoption, or that other facts exist to where the law sets forth an avenue that we don't need the biological parents' consent in that. Once we get through that, once we get through the consent issue, we then look at whether or not the intrafamily adoption is in the best interest of the children. And that's something more similar to an evaluation we've talked about like in custody before. But so when we're looking at the termination portion of it, there are two avenues that a party would not need the biological parent's consent. And those two are either non-payment of child support in violation of a child support order for a period of at least 6 months, or there not being a significant relationship, no significant contact between the biological parent whose rights we're trying to terminate and the minor child that we are trying to adopt.
Right, and so a couple of big things to look for there. A, the child support had to have been court ordered.
Correct.
You see this all the time, my ex hasn't paid anything in years. Well, do you have a child support order? No, I knew they weren't going to pay, I never pursued it.
Right.
All right, well, then we don't have that factor.
Correct.
All right, at least under this article. Now, second to that, you have the no contact provision, all right? And it's failure to visit, to communicate, or attempt to communicate. It's a pretty broad, standard there.
Oh, yeah.
Okay? And that attempt to communicate can get a little hairy.
Absolutely. Yeah, because it is broad, like you said. So it's not just, hey, did we attempt a phone call? Did we send a text message? Attempt at contact can look like, did you send a postcard? Did you send a birthday present, a birthday card, any holiday? Did you make contact on that?
Did I text mom and say, hey, I'd like to talk to little Timmy?
Right.
And she ignored me, or she blocked my number. It gets into the weeds there. And that consent issue, if you cannot meet one of those exceptions to consent, then it stops the game.
Correct.
It's over with. You cannot do the adoption.
Correct.
But assuming you have either the other side's consent, or you have one of these grounds for failing to need their consent, you don't need their consent, then we go to best interest. And let's tell them a little bit about best interest.
Yeah, so best interest, that's something you hear family law attorneys talk about a good bit. That's relevant in custody, it's relevant here, the same in adoption. So when we say best interest, the law sets forth about 14 factors. It is not an inclusive list, okay? So there are things outside of that could also be factors.
I like to say best interest is anything the judge at that time determines it is.
Absolutely correct. And when you think about the world of custody, what's relevant to the safety and well-being of a child? Everything is relevant to the safety and well-being of a child in your household. No, outside of your household, you as a person, the whole situation.
But we've talked about law changes before. One law that changed a few years back was that there is a primary factor now.
That's correct.
And that's the potential for there to be abuse.
That's right.
So if you have situations where you've had protective orders in the past, or you've had allegations of abuse, or hey, someone pled guilty to a criminal charge because they committed abuse or child endangerment or something like that, then you could see that come back around in this context to say, okay, well, we got over the issue of their consent. Now we have to prove it's in the best interest. And that number one factor is out there. Well, now you're that much closer to getting where you're trying to go. Absolutely,
yeah. And if abuse isn't a factor in your case, there are 13 others that may be.
Right.
And those 13 factors are just a good starting point. We find those in Article 134 of the Civil Code. But that's a good starting point for where the judges say, hey, here's a starting outline of what I can ask these parties or what I can ask these lawyers to show whether or not this adoption is going to be the best thing for the child or not.
And look, we know AI has taken over the world. So that's a great question to plug into ChatGPT. Hey, what are the 14 factors in Louisiana for determining the best interest of a child? It's going to spit those out to you. You can know exactly what they are, and you can come prepared when you talk to your attorney to say, hey, well, look, factor 7, blah, blah, blah. These are my factual scenarios. Which ones do you think favor me and don't? Great questions to get. We love when clients come prepared. We try to come prepared when we're meeting with you on your case. Pull up the case on the clerk's site, know a little bit about what's going on, not just walk into the consult blind. And I love when clients take that initiative too.
Absolutely.
So, run away from an attorney that's afraid for you to ask them some questions about the law that you've done a little research on. They either need to set you straight, say, hey, that's not exactly how that plays, or
AI can be wrong.
right, they need to answer your questions. Now, I'm going to throw you a little bit of a curveball here.
Sure.
Something we do that I haven't seen anybody else doing. There are ways, if you don't meet the 1245 factors that we talked about when you don't need the other party's consent, if you don't meet those, there are other ways under the law to terminate the parental rights to get your child eligible for an adoption. I'm not going to go into all of them here, but they are a little bit more broad, but they're harder to do. And the procedure for it is very, very nuanced, and you have to do it very, very particularly. We have successfully done 3 of these. I have 2 of these pending right now. So even if you don't think that an adoption is viable, but you really do believe it's what's best for your child, I still encourage you to meet with an attorney.
Absolutely.
I'd love for you to meet with us so that we can sit down and look at your specific facts, specific law, and say, hey, can we find a way to get through an adoption process? Because just one war story here. I had a client that came in. She had recently been, the other side had filed something to modify custody. And when she was telling me the story, I was like, man, I mean, this is awful. She says, I said, what do you really want out of this situation? She goes, I want my husband to be able to adopt my child. This biological father hasn't been in the child's life in years. The child doesn't even know they exist. But there was no court-ordered child support, and because they had filed that pleading, that was an attempt to communicate.
Right.
And so the case law had kind of shut the door on them. So we went through this other avenue, and we finalized that case with an adoption. And that's really that's the last thing I want you to talk about is that adoption day, that court hearing.
Yeah.
What's that look like?
Oh, it's the one truly happy day in family court that we get. Because typically what the court does is they'll do something called bifurcation. They will separate out the 2 kind of parts that we're talking about. We're going to have a court date to talk about the termination of the parental rights, whether or not we need consent, and whether or not we were able to circumnavigate the consent.
That other parent has to be there for that, or has a right to be there, has to be notified. But once the court concludes we're terminating those rights, and we do find it's in the best interest, then they're no longer a part of this.
That's right.
And that next hearing date,
that next hearing date is the adoption part. That's where we then called what's filiate. We filiate the adoptive parents to the children that are being adopted. So that's kind of, if you've ever been in the courthouse, if you've ever seen people around the courthouse, they all get to come in their shirts that day and have a photographer, and that gets to be the happy celebration for this newly formed family.
That's right. It's one of the best things we get to do. So I hope this answered some good questions for you. Once again, Erin Abrams, Jonathan Johnson, right here in the Johnson firm in Lake Charles, Louisiana. Hey, we appreciate you watching that video. If you have other questions about other legal topics, check out our website, johnsonfirmla.com, or our YouTube page. We put out material all of the time in the areas of family law, personal injury, and criminal defense. We really appreciate you checking us out. Thanks so much.